10 minutes in. Where are you going? I just checked. But you go ahead, you've heard my speech. Dr. Stu Gillen is out of town, so I have taken the liberty of emceeing today's meeting. And welcome everybody. I recognize everybody, so we don't need to go through any legalities and everything. Announcements, I just have some little housekeeping for you. You all know about those Zoom meetings with the Parkinson's on the second Wednesday and the Care Partners on the third Wednesday. We're meeting at Wood Library in person the last Wednesday of each month, 1 o'clock. For future meetings, we're putting together the program for next year. We're interested in your speakers of interest and topics. Let us know, any of us know, and we will work on the speakers for next year. Let's see. We're also, the Red Stars is your steering committee. We're looking for new members to join our steering committee. We meet on the first Wednesday of each month by Zoom at 10:30 in the morning. If you'd like to see how we operate, listen into our session. We'll email you the agenda. We also take minutes. Okay, so let us know and we'll get you on the email list for the agenda and then join us. And we'll have Gail email you the links to the Zoom. Remember, availability of funds to help pay for your medical devices, wheelchairs, canes, ergonomic utensils, anything. We won't pay for it, but we'll help you pay for it. So the form is on the website. I brought one extra. I can't find my folder at home. It's there someplace. So that's what the form looks like. You can print it out and send it in the mail to our mailbox. And the address is right on there. Okay. A date to remember here. Our annual picnic. We had it last year. And this year it's Wednesday, July 27th from 11 to 1. Again at our House Park Pavilion here in Canandaigua. Please bring your own lunch, including beverages and table service. We plan to light the grills. Okay, so go ahead and bring your own hot dogs and hamburgers. And Bob's going to light the grills for me. And then you'll be able to make your hots and burgers or chicken or whatever. We're not asking, due to COVID concerns still, we're asking not to bring a dish to share. So bring whatever you're going to have for your lunch. We're also going to play several games of bingo. So Gail is going to email reminders out with the date and everything for everybody with all this information. Today's speaker, Attorney Russ Kenyon from Kenyon and Kenyon Law Firm. One of his specialties is elder law, medical finance, estate planning. And thank you, a common question we have, what is elder law? So, thank you.
Thank you.
Okay, I assume you can hear me because I could hear Trish without the microphone, but I think for the recording it's better if I keep it. I'm going to stay back away from everybody. Can I take my mask off so that you guys can hear me a little bit better? Is that okay? All right, just hold your breath for the next 45 minutes or so. I think we'll be okay. So my name is Russ Kenyon, and I have been practicing. I started with my dad 29 years ago this summer here in Canandaigua, and ever since I was in law school, starting about 30 years ago, I've been working in or concentrating in the area of elder law. Elder law is simple. It's law for old people. But the funny thing to me is that old people get younger and younger every single year from when I started. When I started, I was 24 years old probably, and you know, I'm thinking 65, they say the definition of an elder law attorney is somebody who concentrates in an area of working with people that are 65 or older. 65 was a long way away back when I started doing this. It's a whole lot closer now. Essentially, the things that I do is work with people, and whether they're 65 or older or 65 or younger or whatever, I work with people and try to help them deal with day-to-day things. Whether I'm working in a elder law situation or in a traditional, younger person situation, I'm trying to find ways that I can help my clients deal with the two things that everybody has. And what I've done over the years is, in order to keep things simple in my mind, I look at what I can do for my clients, and there are really only two different things that each client has. You have your things, your assets, your house, bank accounts, vehicles, toys, collectibles, retirement, Social Security, all of these different things I like to call your stuff. I'm a big George Carlin fan, and George Carlin used to have a bit about a place for your stuff that must have taken hold when I first heard it, way younger than I should have heard it. And so that's one of the things that you have is your stuff. The other thing that everybody has is your person, care, treatment, dealing with doctors and hospitals and facilities and procedures, and just having care, medical care, psychological care, whatever you want to call it, dealing with what I call your body. So really, in my mind, the things that I help people with, there's only two things. I help you with your body and I help you with your stuff. So that makes my job easy. I've only got to know everything there is to know about two different things. Then I look at the time periods that I can help people with. A lot of people come to see me about doing a will. And if you're coming to see me about doing a will, you're thinking about things that happen when you die. Great, I love doing that. That's something that I do. Death and taxes, the only two certain things. The other time period, though, is until you die. So if there are two time periods, after you pass away and before you pass away, and there are two things, your body and your stuff, there's really only four things that I can help you with. I want to help you deal with your body, manage your body, take care of yourself. Now, I'm not a fitness instructor, I'm not a nutritionist or anything like that, but I want to make sure that there is an ability for you to have input and access to and control over how your care is provided, what's included, that your wishes are followed, those kinds of things. I want to help deal with your body after you pass away, so that's the second thing. I usually hold up 4 fingers. Your body before you die, your body after you die, your stuff before you die, and your stuff after you die. When I talk to my clients about dealing with your body after you die, that's a pretty quick discussion because it's none of my business. And today I want to talk mostly about the stuff while you're alive, but let me give you the speech because I've practiced it a lot of times and I really kind of like it. Dealing with your body is up to you guys, and my advice to my clients has always been know what you want, make sure your family knows, burial, cremation, funeral, services, memorial, wake, whatever it is you want to have happen. Know what you want and tell your family. All right, we're halfway done. Let's talk about your stuff while you're still alive. I want to make sure that there is a means, a way, a method for you and your family to help you deal with your assets, your banking, your insurance, your retirement, all of your different things when you're still alive. And then the will is really pretty simple, dealing with your stuff after you die. Again, that's not what we're going to focus on today, but that's the fourth thing, is your stuff after you die. I have spoken to this group before, and I'm not going to give you guys a quiz on all the different great things that I talked about, but I've talked about that thing, and the two main things I want to talk about today are dealing with your body while you're alive and your stuff while you're alive. And what I was kind of hoping to do today was give you a little bit of an update of the way, in my mind, my practice has changed, is adapting over the last couple of years, just based on things that I'm seeing kind of sort of in the community, in the practice, in the application of the law to my clients that are, living their lives. The third thing that I want to talk about, and I'll talk about that third, but I want to talk about an article that was in the paper a couple weeks ago that had a lot of clients upset, concerned. There was an article about millions of people are at risk of losing their Medicaid coverage, and no, they're not. It's a great article, great headline, but I want to just talk about that real quick. But what I wanted to do is give you just those three quick topics, And then I just want to open it up to questions. And I really want to take the time to answer questions, because invariably I give a presentation, I get through my allotted time, and there's still an awful lot of questions that people have. So let me go back and tell you the 3 things that I want to talk about. And if you have a question in the middle of this, just jump right in. I'm not going to wait till the end. I'll forget what I was talking about by the time we get to the end. So first thing I want to talk about is things that I've been doing, talking about your body. Now, the thing that I like to tell my clients when you're dealing with your person, with your care, with your treatment, is that, and this joke doesn't work very much with the kids today, but you're always with your body, unless you're like Shirley MacLaine. You remember her out-of-body experiences. So the importance of that statement is that a healthcare provider, a doctor, a nurse practitioner, a technician, anybody that you may be dealing with in a medical or other care type of situation, you're right there. It's not like my wife can take my body in while I'm mowing the lawn and have the doctor work on it and then bring it back and give back to me when I'm done with it. I'm always there. Now, the importance of this is that if a care provider has a question about my wishes or my beliefs or my desire or my, what I want to do, what I want to accomplish, how I want to live my life, or quite frankly, how I want to die my death, they're going to ask me. So that's a very important concept, and it's a concept really on which our whole country is founded. I'm the only one that has the right to tell anybody what to do to me, what to do for me. I'm married. My wife has absolutely no legal right to talk to the doctors about my care. I have 2 kids. My son just turned 19, my daughter just turned 21. I'm out of luck. I can't talk to their doctor anymore. I can't call and ask for lab results. I can't direct any kind of treatment or anything along those lines. And that can be a problem. I mean, it's great. I love it. The whole concept, the historians or the political scientists will call it self-determination. My kids called it, you're not the boss of me. But the concept here is that I am the one that decides what happens to me, which is awesome, until I lose the ability to communicate effectively with my healthcare providers. What do? I do a healthcare proxy, okay? A healthcare proxy is a document where I give someone else the ability to speak on my behalf, to communicate with my providers regarding my wishes, my thoughts, how I feel about certain types of treatment, what my course of action would be based on the circumstances that I'm in. Very, very important, because if I don't have in place some kind of a vehicle to allow someone else to speak to my healthcare providers on my behalf, the only remedy that we have is what's called a guardianship proceeding, which I love guardianship proceedings. It's an area of law that I've always enjoyed. It just happens to be an interesting area of law, and it makes me a ton of money because it's ungodly expensive to do a guardianship proceeding. It's ridiculous how expensive it is. My goal is to never do another guardianship proceeding as long as I live, as long as I practice, because I want to have all of my clients have healthcare proxies. If I have a healthcare proxy, and if I lose the ability to communicate with my healthcare providers, my healthcare agent can do it. That's what I want to have happen. Okay, so the very first thing that I say to my clients is, no matter what else we do, I got to give you a healthcare proxy. We've got to do that. Now, let me just give you a real quick history on healthcare proxies. The first thing that came along was not a healthcare proxy. The first thing that came along is what's called a living will. Back in the early 70s, nothing like this existed. There wasn't even really a concept, but there were a couple of cases. There was one case in New Jersey. This woman named Karen Ann Quinlan was brain dead, and her family had said to the doctors, we know Karen, she would not want to, be alive in this situation, and the situation was such that they were able to keep her alive, but she was plugged into machines. And there was another case, Cruzan down in Texas, and they all kind of popped up at the same time. Long story short, the end of the day, the determination was by the US Supreme Court, we have the right to withhold or withdraw life-sustaining treatment. Okay, so that's how it all started. It all started with a living will. The court said, yeah, you've got that right, but in order to exercise that right, we'd really love it if you write it down. Okay, so that's what a living will is. A living will is a statement that says, if I am terminally ill, if I am permanently unconscious, if my health is such that there is no reasonable expectation of my recovery, then I do not want, and then you can put in however, whatever your wishes are. And I've customized a bunch of different healthcare proxies. But that's what a living will is. So a living will says, here are my thoughts on end-of-life situations. Okay, now we've got the living will. It's a court-approved concept. People started to try to expand it. Here's my living will in 1975. All right, if I'm at the end, I don't want this and this and this, and if you have any questions, ask my wife. Okay, that really wasn't part of the court decision. That was something that people started throwing in there. And various legislatures, in a never-ending quest to get reelected, decided that they would pass some kind of legislation creating something new. And what you're doing when you say to the universe, look, if you've got a question, Doc, just talk to my spouse. She'll tell you what I want. That's an appointment. That's a creation of a job. That's something like a power of attorney. In fact, that's what a lot of other states call these healthcare proxies. They call them healthcare powers of attorney. So the legislature said, we will allow you to appoint somebody to talk for you. Cool, awesome. Everybody started doing these healthcare proxies or healthcare powers of attorney. They didn't do living wills anymore. Then somebody ended up in the hospital with a healthcare proxy that said, talk to my wife. My wife said, he doesn't want to be plugged in. And the doctor said, okay, how do we know that? Oh, geez, we got to keep doing those living wills. So the way that I do it now is I do a healthcare proxy that says, I appoint so-and-so to be my healthcare agent. And then if you have any questions about my beliefs, here in my living will, and it's all part of one document, here are my wishes. And it can be anything you want. It's not a statutory, the living will part is not statutorily created. The living will is just a recognized right to tell the universe what your thoughts are. I've done all sorts of different kinds of living wills. Jehovah's Witnesses have a very specific one, and they have gone out and said, here's what we want it to say. I've done different religious ones. I've done a very conservative Jewish one. I've done a regular kind of Jewish one. One of my favorite stories, very devout Catholic client asked me about a Catholic living will. Said, I'll take a look, I'll see what I can figure out. And it's a really, being an elder law attorney is not a real sexy kind of thing because there's not hot, great cocktail party discussion kinds of topics to talk about. But when Pope John Paul II was sick, there was a big question about what would happen in his end-of-life situation, whether or not the teachings of that particular belief set, how would they interact with his medical condition. So that was kind of cool for somebody like me because, I'm a weird elder law planning kind of lawyer, so it was a neat topic. In any event, the moral of the story is I went and found the United States College of Cardinals, or whatever it's called, got together and created a Roman Catholic living will. I found it, I used it. They said that you could use it, so I wasn't stealing. I don't want to steal from anybody. And I put it together, and it set out exactly what she told me her wishes were. Gave it to her. She came in to see me, and she said, yeah, my priest doesn't like your living will. I said, I don't know how to break this to you. It's not mine. It's his boss's boss living will. I didn't, but anyways. So the living will and the healthcare proxy, they work together. Now, the living will, it's important. You tell me, any, an elder law attorney, whoever you're working with, you tell them what your thoughts are. I had a client tell me, Russ, I want you to put this in my living will. If I'm in a nursing home, once a week, take me out, and if I'm too stupid to come in out of the rain, leave me there to drown. I didn't say it quite like that, but I did kind of get that expression of belief, and it's, when I no longer have the ability to be aware of all this fancy lawyer stuff that I put in there. I've had people tell me, tell you what, I want you to go to the attic in the hospital and find every machine you got and plug me into it and go all the way to the basement, try everything you got. I want to be hooked up. I don't want, and people have said that, all sorts of different beliefs. So the importance of the living will is making sure that there is a statement out there regarding what your end-of-life wishes are. All right. That's not what I wanted to talk about. What I wanted to talk about is the healthcare proxy. For years, just real quickly, as far as the healthcare proxy goes, when you create a healthcare proxy and designate an agent, you have to designate a primary agent. And then I like to do at least 2 alternate agents. So it's got to be your number 1, your number 2, your number 3. If you can't get a hold of 1, go to number 2. If you can't get number 2, go to number 3. I've had people say, look, just name my 3 kids. And whatever 2 out of 3 of them agree to, that's what I want to have happen. We don't like putting doctors in that position. We can't do that. So we got to have a 1, we got to have a 2, and we got to have a 3. That's just the way the law reads. That's the way that I do it. Okay. Finally, I'm going to tell you what I want to talk about. So for years and years and years, I've had clients come to me and say, I've got a healthcare proxy. I'm pretty aware of the fact that when you're coming to see a lawyer, my services are not inexpensive. You're putting out a lot of money to have me help you. So people a lot of times will say, look, I don't need a new healthcare proxy. The one I downloaded off the internet is fine. It's totally okay. And I'll say, okay, let me take a look at it and make sure that you didn't have the agent act as the witness, because you can't do that. But for years I would say, yeah, your healthcare proxy is fine. Don't worry about it. We don't have to do a new one. And it just made my clients feel better that they had one. And I'm going to tell you right now that if you have a healthcare proxy, that's fantastic. And I'm not trying to sell you a new healthcare proxy, but here's what I am telling you. I've been involved for a little while with the ethics committee at the health system, and every once in a while we'll have a consult where there's a question regarding the healthcare proxy or the living will. And the question that arises is that still the patient's wishes? So the first healthcare proxy I ever did was probably in 93 or 94, right after I started practicing. The law doesn't say that that expires. The law doesn't say that you have to do a new healthcare proxy every 5 years or 10 years or anything like that. Any healthcare proxy that I did in 25, 30 years ago is still valid. But I've started to believe that if I get into a situation where I have family members that are trying to enforce, if that's an okay word to use, the provisions in my living will, for example, and somebody comes along, it could be anything. It could be my new girlfriend. It could be my cousin. It could be, I don't know who it is. I don't have a new girlfriend in case my wife is listening. So just the old girlfriend. Is that still his wishes? That's the question that has been raised sometimes. So what I have started to do, this is what I wanted to talk about. I have started going and making a new healthcare proxy in living will that says exactly the same thing as the last one, that says exactly the same thing as the one before that, and the one before that, and the one before that. If anybody ever says, is that really what Russ wanted? I want my family to be able to say, well, yeah, he's done 5, and they've all said exactly the same thing. The reason that I like to do it this way now is I'm trying to make it easy. I'm trying to make it so that your wishes, you tell me, my wishes haven't changed, Russ. Alrighty, let's just say it again. Let's get it out there again. And then I don't throw away, I don't destroy the old healthcare proxy. I've got files where I've got 4, 5, 6 healthcare proxy and living wills. And every time I say healthcare proxy, I typically also mean living will, because mine, they're combined. So it's important to me. I have started to believe that it's important for my clients to build a record, to establish a course of conduct, to say, yeah, haven't changed. In '93, I was healthy as a horse. I've gotten older, I've had some bumps and bruises, but my wishes haven't changed, and they don't change. And all that I'm really trying to do here is make sure that your wishes stay out there for the universe to see. Now, what if your wishes change? That's cool. They do. I mean, there's absolutely no doubt about that. And you come and you talk to me and I say, my wishes have changed, my thoughts have changed, my beliefs have changed. Not a problem. I want to make sure that we do that too. So if you've got a new front that you want to put out there, let me know and we'll do that as well. So the focus now that I have when I talk with clients about healthcare proxies and living wills is the effort that I can put out there to make sure that your wishes are followed no matter the circumstances. It's a little bit different than the focus over here of, well, what are the legal requirements of a healthcare proxy? You guys can Google that. Now, you're not going to be able to do it as good as I am, but that's just because I'm really good at what I do. But anyways, I am more interested in the practical application of documents like this and making sure that there's no question what you want is going to get to the people that are going to be in charge of making those decisions. One last thing on that topic. There is a book that the AARP puts out, and it's called The Other Talk. And it's a very important part, in my mind, to the whole estate planning, disability planning concept. The first talk that you have with your kids is the birds and the bees. You guys shouldn't have to have the birds and the bees talk with anybody ever again. But the second talk, or the other talk, or the next talk is end of life stuff. Is I'm not immortal. I do have an expiration date out there. There are, and it's very important in my mind that you have a conversation with your family to make sure that they are aware of what your wishes are. So it's not a big surprise to them. And then if you have somebody in the family, I had a couple in my office probably 20 years ago, and the husband, they were in their late 80s, and the husband said, listen, I know exactly what my wife wants. I could never tell the doctor that that's what she wants. I could never tell the doctor to pull the plug, so to speak. Now his wife said, listen, I'll pull the plug on you tomorrow if I could, or you're driving me nuts. But so in any event, we picked somebody else to be the one to be the communicator between the healthcare proxy, between the care providers and the principal. All that I'm trying to do, the focus is on making sure your wishes are put out there, followed to the best of the ability. Okay? So that's one of the things that I wanted to talk about. The next thing that I want to talk about is the power of attorney. Now, power of attorney, I have a love-hate relationship with powers of attorney. I have a hate, love-hate relationship with powers of attorney. The power of attorney form when I started practicing was one piece of paper. It said, anything I can do, you can do. Anything. That's exactly what I want it to say. I don't want there to be something that my agent can't do. I, as a planning attorney, it's very important to me that anything can happen. I've got no idea when you're sitting in my office. I've got no idea when I'm sitting in front of an attorney what types of things I might need to use a power of attorney for. So I want my agent, we call him an agent now, there to be able to do anything, everything. So it made a lot of sense to me to have a document that said, anything I can do, he can do also, to paraphrase a great song. That didn't work for some reason. The form that we had in New York, there were banks, insurance companies, investment companies, governmental entities. They said, yeah, no, we don't accept the New York State power of attorney. So New York State said, well, why not? Well, it just says anything I can do. You gotta be more specific than that. So the New York legislature came along and said, oh, have we got a great idea for you? We got a 2-page power of attorney. It says, here's a list of all this stuff. Real estate, banking, insurance, investing, personal property, anything else. Sounds good to me, sounds like it covers everything. Not good enough, no. I actually had a bank call me one time and say, I was in a situation where we were trying to take a joint bank account and make it a solely owned bank account. The person, one of the 2 owners of the bank account had lost their capacity, so we were using the power of attorney to essentially sign away that person's interest in this bank account. So the bank called me and said, well, my client called me, I'm down at the bank and they won't let me use your power of attorney. So I talked to the bank and they said, well, you didn't authorize the agent to do what you're trying to do. All I'm trying to do is take one person off of a bank account. So I said to the person on the bank, on the phone, you guys are a bank, right? Yeah, sure, it's right in our name, such and such bank. Okay, and my client's down there trying to transact some business with you, right? Oh yeah, absolutely, that's what they're trying to do. So would you call that a banking transaction? Oh, absolutely. All right, take a look at paragraph A. It says banking transaction. Oh, well, no, you're not really trying to do a banking transaction. You're trying to make a gift because you're taking somebody off of an account. You're giving that person's interest to the other person. I said, oh, you're absolutely right. God, you're a real smart guy. They did a great job at training for you. Do me a favor, turn to page 7. What does that say? That says that they can make gifts. Okay. Then turn the page, keep going. They can make gifts to anybody in any amount. I said, fantastic. So we're good, right? No, we just don't accept your power of attorneys. Oh, God. All right, so eventually the power of attorney form, up until last June, had gotten up to about 13 pages. How do you think I like going through a 13-page document? First of all, my dad's a trextodextrophobiast. He hates a number 13, so I'd have to throw extra stuff in there just to get it to 14 pages. But that's too long. So it's back. I'm down to about 11 pages now, so that's a little bit better. But the good thing now is it has said, the power of attorney says, here's a list of stuff. That's the first couple pages. I put 4 pages of extra stuff. I call it stupid stuff that such and such a bank makes me do. I don't use that nice a language because that bank really ticks me off. There's a provision in the law that says if you follow this form, they got to take it. The banks have got to take it. The insurance companies have got to take it. The investment companies have got to take it. Governments don't have to take it. I'll talk about them in just a second. But if they don't take it, I can sue them to make them take it, and I get lawyer fees for making them take it. So it's cool now. It's better, and I love it. I hate it because it's still 10 or 11 pages long, but if I do it right, and I do it right, you gotta take my power of attorney. There's no way that I can't have my client do what I need my client to do by using the power of attorney. All right. Governments, the government. The IRS does not believe in powers of attorney. The IRS has their own power of attorney form. Social Security does not believe in powers of attorney. It's a whole federalist kind of thing, and states' powers versus the federal republic powers and all of that. Get back into Alexander Hamilton, and I can rap to you the Hamiltons, but I'm not going to. I couldn't. But the federal government doesn't like state powers of attorney. They made their own power of attorney. So what I do is I take the IRS power of attorney and I fill it out and I sign it as the New York State power of attorney. And the IRS is like, oh, okay, cool, thanks. You filled out our power, but they don't care. They're so stupid. Yeah, we'll take that, even though we don't believe that you have any power whatsoever under the New York State power of attorney. You can sign our power of attorney using the New York State power of attorney, and it's just like they signed our power of attorney. Okay, cool. All right, so here's what I want to talk about with powers of attorney. For years and years and years and years, let's say I would name, my mom and dad come to see me, and I say, all right, Mom, I want you to name Dad as your power of attorney. And then I want you to name child number 1 and child number 2 as your alternates. That makes sense. Everybody, almost everybody, has utmost confidence in their spouse, been together for years. They're the ones that you want there with you as your primary agent. You don't want to bother the kids. You don't want to have that. Maybe you've got a kid that really likes spending money. There's just a concern. We're not going to name the kids as a primary agent. We're going to name them as secondary agents, and that's all the way I've done it for years and years and years. Again, I've started changing my mind a little bit, just like I did with the healthcare proxy. Now what I like to do is I would say to my mom, look, you name Dad and me as your primary agent. By naming both of us, if something happens to Dad, I don't have to prove that something happened to Dad. I just prove that I am who I am. So now I'm a big advocate of having 2 primary agents instead of 1 primary and 2 alternates. I name 2 primary agents, and then I name, an alternate or 2 alternates, or 10 alternates. I don't care, as many as I can. Does this mean that if you guys have a power of attorney, you should come see me and do a new power of attorney? No, not really. But the next time you're thinking about it, if you start thinking, hey, I want to change my will, don't limit yourself to, I want to change my will. Let's look at the big picture. Your will is easy. What happens when you pass away? The law is pretty clear. I'm more worried to make sure that you got the things in place while you're still alive. That's more important. We can figure out what's going on with your stuff. Let's deal with your person. Let's deal with your assets while you're still alive. So the focus now that I have started to direct or advise is that you name 2 primary agents. So all that they have to do is walk in and say, here's the healthcare proxy, here's my driver's license, this is what I want to do. They say, oh, okay. So that's just become a little bit more of a practical application. It's a little bit easier. All right, the third thing, the last thing I want to talk about, there was this great article in, I think it was in the Messenger, and it was a national article because, the Messenger doesn't do any original local articles anymore, unfortunately. And it said millions at risk of losing their Medicaid. And I'm not sure how many of you are in a Medicaid situation. You might be some point, you may never be in a Medicaid situation. But it was a great opportunity for reporter to write an article to try to scare people because of a couple of different things that are happening. Essentially, during COVID, when you go on Medicaid, and Medicaid is something I could talk to you guys for hours about, but when you go on Medicaid, the law used to say you have to recertify. And at first, it was every year you had to recertify. And all that they're asking you to do is to show them the financial situation. Make sure that you didn't win the lottery. That you don't have, a whole bunch more money than you're allowed to have, because Medicaid is a needs-based benefit. Then, right before the pandemic, the government got out there and said, recertifying every year, that may be a little bit too much. For certain people, we're going to let you recertify every couple of years. Okay, cool, that's great. Then the pandemic hit, and Medicaid essentially said, to heck with it, we're not going to recertify anybody anymore. Because we're too busy trying not to die. We're too busy trying to stay socially distanced. We're too busy, we got other things to worry about. We're not even allowed, family members, we're barely even allowed to go into nursing homes to see people, to get the information, to do all of that. So the way, up until just very recently, the deal was, if you were on Medicaid, don't worry about a thing, you're always going to be on Medicaid. The way the article was headlined, or the way they led the article, was, oh my God, all these people are gonna lose their Medicaid. All that's happening is we're going back to the situation we had before where you're gonna have to recertify again. So the reason I wanted to talk about that is in case any of you guys read that article, don't worry about it. It's not a catastrophic kind of thing. You just have to make sure that you get the financial information to the DSS here in Ontario County and Monroe and Livingston and Wayne and Yates and all that. There's no new rules. There's no longer look back period. The amounts that you're allowed to have actually increased. So Medicaid is not at risk of collapsing. Medicaid benefits are not running out the door. Don't worry about it. I'll talk with you at length about Medicaid whenever you want, but that's what I wanted to talk about. Let's do a healthcare proxy as many times as we can. Let's multiple primary agents on the power of attorney, and don't read that stupid article. Okay. So I left some time, I think, for questions. Somebody's got to have a question. Yes, ma'am.
What happens if the two people you put on your power of attorney have an argument? Is there any way of adjudicating what happens then?
So the question for the recording or anybody else is, what happens if the two people that you name as your power of attorney have an argument? What happens then? There is no clear-cut answer to that. An answer could be litigation. There is one thing that could happen is you could have a lawsuit, one agent suing another agent to have a judge decide what the appropriate thing to do is. Another thing that can happen kind of in that same vein, but not really what you're talking about, the power of attorney enables you to appoint a monitor to be someone that, like, watching over. And I'm involved in a situation right now where we believe the power of attorney mismanaged her powers considerably and essentially stole thousands and thousands of dollars. So we can bring an action in Supreme Court about that, or what we did was we called the Sheriff's Office, and they're helping us investigate this situation. If I have two agents that are conflicted over yes, do this, or no, don't do this, that can be a tough spot. The way, if you think that's going to happen, the way around it is to have a primary, then a secondary. But I spent 10 minutes telling you how I want you to have two primaries. There's no easy answer. I can tell you, as long as my ethics professor from law school is not listening, there are times that we will name someone as a particular office holder, like a power of attorney. I had a client, the only person that he had was his son. No siblings, his parents had passed, very, very ugly divorce, nobody. His son was 18, had just gone to college and learned what an incredibly tasty beverage beer was. So he didn't want his son to know that his son was the power of attorney. But there was nobody else, so we named the son the power of attorney. We just never told him. And we told the son, if there's a problem, you go see the lawyer. And the lawyer will help you do whatever you have to do. That's a lot of responsibility for me. I'm not sure that I like that kind of responsibility. I'm not completely sure how that falls within the ethical responsibilities of my chosen profession, but it was the right thing to do, which I call that the Wilford Brimley test. That was the only way to do it, because he was a young guy. He was in his mid to late 50s, healthy. Anybody can get hit by a bus, so we had to have it, and we kind of pulled the wool over the son's eyes and just never told him. So that could be a way. One way that I could do it is I could name my spouse and not tell my daughter that I named her as a co-agent. Then she doesn't get involved until something happens to my spouse. They say that bad facts make bad law, and sometimes you get a situation where families fight. So I don't have a clear-cut answer for you. I have more of a practical, this is how I would try to deal with it. You can also try to do mediation, you can also try to do arbitration, you can try to do alternative dispute resolution, there's all sorts of things you can try to do. If you know, like I'm not gonna name my son and my daughter who hate each other, I'm asking for trouble if I name them both. So, my job is to ask you stuff like, hey, how do your kids get along? Oh, they hate each other. Oh, okay. Maybe there's another direction that we could go here. Any other, yes ma'am?
When you were talking about bank accounts and if somebody is, they can't make decisions, do you have to take their name off? Or?
No, you don't. The reason that I was doing that was from a Medicaid application standpoint. The applicant, the individual that's in the facility that we were applying to have Medicaid pay for their expenses is only allowed to have X number of dollars in their own name. It's $16,000 is the number right now. This joint bank account was $40,000 or $50,000. And Medicaid looks at joint accounts as being wholly owned by the applicant. So Medicaid looked at that particular bank account as being $40,000, and this guy was only allowed to have, back then it was $15,000. Actually, back then it might have been $12,000, but that's why I did that.
I wonder if it'd be better to have separate bank accounts?
Yes and no, and let me, so that gets into a discussion about end of life, not end of life, death situations. Assets pass on death. There's three main ways that an asset will pass when somebody passes away. And the first of those is based on how that asset is owned, okay? So my wife and I have a joint bank account. And what that means is that my wife owns the entire bank account and I own the entire bank account. We both own the entire account. If I die, she still owns the whole account. So on my death, that account stays hers. I don't need a judge to tell the bank that. I don't need the court clerk to tell the bank that. That just happens automatically. It's an operation of law. That's the way that it is. Then, so that's the legal theory. That's the answer I would have given you in May of 1993. The answer I'm going to give you in May of 2022 is after I die, I'm going to get a check from the Auto Club. I'm going to get a check from Spectrum. I'm going to get a check, my final retirement check, and they're going to be payable to me. Now, I've passed away, so legally I'm not supposed to have the ability to cash while I'm dead. My spouse is not supposed to have the ability to cash a check in my name. She can't just forge my name on the back, which is what I do now. But, and this is great because I do a lot of work with Canada National Bank, and one of their bank, the manager of the main office, Deb Roth, she advises her people, and I do the same thing. Keep your spouse's name on the account. Don't even tell the bank. 2 months, 3 months, checks are going to roll in. Take a check with your spouse's name on it. Go to the drive-thru. Give them a deposit ticket with your spouse's name on it. Then they'll deposit it in that account. And do not ask, oh, my spouse passed away, is it okay if I do this? Because the answer is no, you're not allowed to do that. So a lot of times, for more reasons than not, I would rather have joint bank accounts. That was a very specific situation that I wanted to have separate bank accounts. But for the most part, I want to have a joint bank account for a couple of different reasons.
And for insurance and that, if you have beneficiary listed, you don't have to worry.
Benefits, so the three ways, I left you hanging, I'm sorry. The first way the property passes when somebody dies is based on how you own it. So if you're a joint owner with someone else, I could have 10 people. We all own the camp on the lake. I die, there's 9. He dies, there's 8. The last one standing owns it. That's one way, is the ownership. The second way the property passes is a beneficiary designation. Life insurance policy, retirement account. There are these things called TOD or POD accounts, transfer on death, pay on death. You say to the bank or you say to the investment company, my money, okay, it's my account, I've got control over it, I manage it, I can take money out, I can put money in. I've never understood why a bank won't let somebody else put money in my account. I want them to let anybody in the world put money in my account, okay? But when I die, I want you to give it to Mackenzie, my daughter. That's a pay on death account. That's essentially naming a beneficiary for my bank account, or my investment account, or my CD, or my bond, okay? Then the third way that property passes is going to be through my estate. And it can be a couple different ways. There are certain things that a surviving spouse is entitled to. By operation of law, when your spouse dies, you're entitled to the family Bible. It's yours, okay? That shows you how old this law is. Now, in addition to the family Bible, a computer and all the data on a computer, okay? Modern twist on an old law. This one I love. Domestic farm animals and enough food to feed them for 60 days. So you get your chickens, you get your pigs, and you get your cows, because mama's got to eat. You can't say, look, those were the husband's chickens. You don't get those eggs. You got to get the judge to give you those eggs. Nope, you get that stuff. You get a tractor, get a lawnmower, you get a car. Okay, so I've had a lot of clients they come see me, I give them this form, they take the form to the DMV. You don't even have to come see me, I just know what form it is. And you say to the DMV, my spouse died, had this Corvette, I want it, and they say, okay, it's yours. And you also get up to $25,000. So you can go to a bank and you can say, my spouse had a bank account in his name alone. He never put my name on it, that son of a gun. I told him to, he never did. But he's passed away, I want it. And they say, okay, here. And they can give it to you. Now, the really cool thing about that, these are called family rights or spousal rights. I get that bank account regardless of what my wife owed to people. So my wife dies and she owes Discover Card $50,000. She's got $25,000 in her checking account. I get it. They don't. So that's kind of cool. So there are surviving spousal rights, which are good. There are family rights, okay? The family can get up to, if it's not a surviving spouse, if it's certain age children and things like that. After that, there is this thing I call a shortcut. The law calls it a voluntary administration. But it's a situation where you go to the court and you say, all right, listen, I know that probating a will is a big deal and it takes a lot of time and it costs a lot of money. It doesn't, but that's what everybody thinks. And my spouse died and we don't have any real property and all we've got is about $50,000 in the bank account at Lions National. Can I have it? Yeah, you can have it. Or one that happens all the time. This is a riot. Well, again, I'm a weird estate planning elder law attorney, so what I think is cool is probably not cool, but in any event, I'll tell you. You guys probably remember Mutual of Omaha and the Wild Kingdom, and Jim's going to wrestle a giant anaconda, and watch while Jim jumps out of the helicopter onto the back of the water buffalo, all that kind of stuff. So I always think of that because all the life insurance companies, Nationwide, Prudential, they're mutual insurance companies. And a mutual insurance company is kind of like a credit union. The company is owned by the people that are insured. So if I have a $10,000 life insurance policy with Prudential, I own a little bit of Prudential. If I've got a $10 million life insurance policy with Prudential, I own a big chunk of Prudential because it's a mutual insurance company. They're owned by the people that are insured. Okay, cool. Late 70s, some rocket scientist came up with the idea of demutualizing. They wanted to take all these companies public. So they offered stock. And the one that I always seem to run into is Nationwide. It's not just Nationwide, but that's the one I always run into. Nationwide demutualized in the late 70s. For every $1,000 worth of insurance coverage that you got X number of shares of stock, whatever X was. They sent letters out to all these people with all the little itty bitty fine print explaining this whole process. Everybody thought it was junk mail, and they kind of threw it away. They didn't understand that. There still are thousands of people that have got the right to stock in companies that demutualized back in the 70s. The funny thing, or the cool thing about Nationwide, in the early mid-80s, Nationwide remutualized. So they said, well, that was a stupid idea. We shouldn't have done that. We're going to go back and buy the stock back from all the stockholders and give the ownership of the company back to the insured. So I had an estate, I'll never forget it. We had to go and get all of the stock because it had demutualized and they never claimed their stock in 1977, 78, whenever it was. We had to go through the process to go and get it, and then we had to turn around and sell it right back to Nationwide because we weren't allowed to own stock in Nationwide because they remutualized. So I can't remember why I started talking about this other than it's a cool story, but you know, that's a situation where all of a sudden I may have $5,000 in stock in Nationwide that I didn't even know about, and I've taken care of everything else that I have. I've got co-owners on all my bank accounts, I've got beneficiaries on all my life insurance, my investment account is TOD. Dang nabbit, I got this $5,000 interest in stock from 1977. What the heck do I do? Well, I can do this shortcut. I can go to the judge and say, Judge, it's a little bit, it's a tiny little piece. Give me the authority to go and get it and do my stuff. And they say, okay, cool, here you go. So there's a shorter way to deal with it. The big chicken dinner, the nuclear out, whatever you want to call it, probating somebody's will, we do that all the time, and there are reasons you want to do it and not want to do it, but essentially, the thing you've got to remember is I don't need to get involved with your will if all of your stuff passes the other way. So a lot of times, if we have a joint bank account, like a lot of people want, if we have the house is owned jointly, if we've got beneficiary designations on your life insurance in your IRA, first spouse dies, we don't do anything. Awesome. Second spouse dies, let the kids deal with it. That's a kid problem, that's not a client problem. That's something that they can deal with. And there are benefits to having stuff go through somebody's estate from a capital gains tax standpoint and other things like that. But that's the long answer. The short answer is I don't always want joint, I do want joint accounts as much as I can have a joint account. Any other questions? Yes, sir.
Yeah, about a year ago, we did a TOD for our son who had access to our account on March death.
Mm-hmm.
At that point, as of a year ago, Carol could not understand what was going on, and she, about that thing, also she was unable to sign her name anymore. But the bank person who knew what this, and she was able to just put a X on the thing. What else do we look out for that situation? She can no longer sign her name.
Well, the first answer I would give you is you have to look out for people that don't know you. Because you probably got away with something that probably was a little bit beyond the policy of an investment company or a banking company. The standard of capacity for an individual to execute, in essence, that's a contract. When you create a TOD designation, you're entering into a contract with the investment company. And I'm going to sign this piece of paper to tell you that when I die, I want you to give what I have to my son. Okay? You have to have the ability to understand the nature of the document that you're executing and the consequences of your execution. So you have to, in order to have capacity to sign a document, you have to know what's going to happen if you sign it. If you don't have a power of attorney, that can be problematic. Now, you can have the capacity and understand the concept. The next question is, do you have the ability to communicate to whoever your understanding? And then the next question is, do you have the physical ability to sign something? I don't care about physical ability to sign something. banks care about it a little bit more than I do. There are laws that enable, permit, allow someone to make an X. You don't have to know how to write in this society. Everybody does, but you don't have to. Also, if you are, I broke both my wrists skateboarding this weekend, I can't sign anything. I have the ability under the law to direct someone to sign something on my behalf. There's a way around that. The real question, the thing that I would say you have to watch out for, is any situation where her capacity is questioned. The thing to watch out for is her ability to prove her capacity. So, to prove her capacity, to prove her understanding, to communicate that she knows that, there is